All right, I'll try to keep it to the time, and I have the challenge of dealing with the legal fraternity here, and I hope, they're not used to that small, short format, so we'll try our best. The topic is all about how India, the regulatory landscape has changed, undergone a big shift over the last few years, and if you look at sectors like FDI liberalization, to fintech regulations and data privacy and other sectors, we have seen a lot of things happening in that space. So in that context, from your standpoint, I would invite perspectives. So I'll dive into my first question directly, without waiting. I want to go to Mr. Butani. I want to start with you. So, how has the, is it okay? Yeah. How has the liberalization of FDI, particularly with respect to the China route, if you talk about, how has that impacted businesses overall in India, in your view?
Thank you first for inviting me. Just wanted to give a context. This is this famous press note 3, which was issued as we slipped into COVID, which kind of made all all investments made by countries that share their borders with India subject to the approval, even if those industries fall in the automatic list. And clearly this impacted the Chinese investments. India was not the only country to take that view. Even United States took that view, but it took a view in a fairly calibrated manner. It restricted FDI in sectors that were sensitive, for example, the telecom sector. We took a view that you need an approval. This clearly resulted in a significant arrest in FDI coming from China. I do recall vividly that there were quite a few funding options that were available insofar as investment from China is concerned. Those also got blocked. Well, it's been 4 years, over 4 years since the press note 3 came into effect. I think there is fair bit of rationale for us to be able to relook at that press note, because in a way you choked the investment that was coming. Whereas if you look at the trade figures, insofar as cross-border trade from between China and India is concerned, that has not shown any material change. So the upward trend continues. We experienced the downward trend in the COVID quarters, but thereafter it continues. So I see very little rationale to be able to continue with press note 3. Restrictions, if any, should be for sectors that are sensitive. For example, sectors that are not under the automatic approval, let's say, for instance, single brand retailing or other sectors, but I think it should be allowed. So I think this is an area which requires a serious review. Thank you.
Thanks. A wonderful point there. Vaibhav, give me an overall perspective of how do you see the regulatory landscape changing? How has it evolved over the last few years and impacted businesses and investments in your view?
Thanks a lot for the question, and good evening everyone, and congratulations to all the BW 30 under 30 winners. It's a special day for all of them. Just to add to what Mr. Butani was mentioning about press note 3, and then I'll quickly walk through some key changes that have happened. I can't agree more with him. I think press note 3 has become a unintended irritant for a lot of people. One of the issues is what press note 3 states is that any direct or indirect beneficial or legal ownership from land border countries will require prior approval of the government, irrespective of the sector. The biggest unintended consequence of that is private equity funds and venture capital funds. These are true-blooded American, European, global funds who are perhaps raising some LP money from China. And unfortunately, because the government has, despite a lot of representations, has refused to clarify what beneficial ownership means, while everybody wants beneficial ownership to be understood as 10%, taking the Companies Act and PMLA and KYC rules, the government's not willing to sort of clarify that. one hopes that with the border tensions easing somewhat, I think it's worthwhile that that issue gets clarified, that what do you mean by beneficial ownership? Because now we have these crazy matters where some global transaction is taking place. One American company is buying out a Spanish company, which has an Indian subsidiary, but because there is some indirect Chinese ownership of 7%, 4 layers above, that triggers a government approval. And I would totally agree with Mr. Butani on press note 3 that, look, Australia did it, US did it, this whole CFIUS approval process in the US is for these sensitive sectors precisely for that reason. But I think in India, we ought to have had a calibrated approach. Perhaps the sensitive sectors is what you should keep out of purview, or rather make it subject to these kind of restrictions. But what is the reason for restricting FDI in, say, automobile sector? We've seen instances where large automobile companies from China have been denied that approval. I mean, and then what is the point of then having huge imports? I mean, it's always better to have FDI. And at what level would you go? I don't know how many of you are aware, but Volvo is ultimately beneficially owned by a Chinese company, just like how Jaguar is owned by Tata's. And now, so any investment that Volvo makes further into India, would that require a press note 3 approval? So it sort of leads to some absurd consequences. I don't think that's the intent of the government. So one hopes that now with border tensions easing, at least the non-sensitive sectors are put outside the purview of press note 3, or at the very least, you clarify what you mean by beneficial ownership so that the private equity funds don't find it a challenge to further put money into the country. Very quickly, I'll touch upon 3-4 big changes that have happened over the last 1 year that are really aimed at facilitating M&A. One is, of course, now the government has realized that you need to facilitate ghar wapsi. A lot of Indian companies, Indian founders had got shares gifted by their lawyers and colleagues and set up holdcos overseas in the US and in Singapore. The Y Combinators of the world were all encouraging that India mein to listing ka koi fayda hai nahi. You will never get valuations. And today, boy oh boy, how has the story changed? Everybody wants to list in India because the multiple that you'll get in India is uncomparable. And so now we are having a ghar wapsi of sorts. Holdcos which were set up overseas, whether it's PhonePe, whether it's Meesho, whether it is Razorpay, they're all now bringing back the holdcos into India. And kudos to the government for having recognized that we needed to do that. So as I'm sure many of you are aware, fast-track mergers where a holdco merging with a wholly owned subsidiary did not require an NCLT approval. You could do that with central government approval. But cross-border mergers did require NCLT approval. So the government sort of changed and clarified that, said as long as a holdco of an overseas jurisdiction is merging into a wholly owned subsidiary in India, we will allow that to happen without requiring an NCLT approval. It can just be done with the approval of the regional director. This is being done to facilitate ghar wapsi. I can tell you a lot of our clients who had set up holdcos overseas to raise capital and with founders sitting in India with some gifted shares are now bringing it back into India because they realize the valuation multiples that Indian market will give you, nothing comes close. So that's been a big, big change. And I'm Mr. Bigchandani, who's the Bhishma Pitama of the startup world, always used to talk about it. And I think his conviction got validated with both Policy Bazaar and Zomato's successful IPOs where InfoEdge is the largest shareholder. And I think that journey is continuing. So I'm very, very sort of happy to note that. Another one very important change that's happened is that as Indian stock market is going to continue to boom, shares will be the currency for M&A transactions, not cash. For instance, I did the Zomato acquisition of Blinkit. Back then it used to be called Grofers. The transaction was a share swap where Zomato actually did not pay cash, but issued shares to the owners of Grofers, which was SoftBank and some of the other funds. So share swaps thus far, particularly for existing shares, required RBI approval. RBI has now changed that rule. So ODI, FDI swaps or FDI, FDI swaps of existing shares, which needlessly required an RBI approval, has now been made under the automatic route. So that's again a very, very positive change. So there have been some very positive changes, and I'm happy to sort of step in subsequently, not take away the limelight from some of the other moderate speakers. So I'll hand over the mic to them. But I think overall it's looking good. M&A per se has gone down because there is an inverse relationship between capital markets and M&A activity. So whenever the capital markets are doing well, M&A does tend to go down a bit. But no one's complaining. Capital markets have been robust, and that's meant good secondary exits to all investors. In India, everybody was investing,
Right.
but they were not getting exits. So last 2 years have changed that trend. So overall, everything looking great.
Thanks for sharing this comprehensive picture and the loopholes that you pointed out to at the same time. Mr. Mehta, let me come to you. So we have seen the recent RBI actions on NBFCs. So give me a sense of what legislative reforms are anticipated for the financial services sector.
So thank you for giving me the opportunity.
I would request you to keep the mic closer to you. Yes.
Yeah.
Yeah.
So
Yeah.
I think one of the thing that has raised this issue is a couple of months back, the RBI had sort of come down heavily on 3-4 NBFC, on 3-4 microfinance companies. And what they did is that overnight they were told to stop dispersing new loans. So they couldn't sanction and disperse new loans. They could only collect on their existing ones. So that sort of, that overnight decision sort of came as a surprise for the entire industry, because these were not like small NBFCs. These were fairly large sized NBFCs we are talking about. I think, so from that perspective, when that happened, of course, now we do hear that one of the NBFCs is out of the woods, and, hopefully the others will follow suit. But I think that really raises the question that if one looks at it, it wasn't, there were, let's say, some, whatever were the governance lapses and all. There are other regulators who have, a broad ranging powers to sort of, let's look at, for example, SEBI. It has powers ranging from penalties to it can do consent proceedings to it can, even prohibit access to the capital market. So they have wide ranging powers. If one looks at the RBI from that perspective, because SEBI has all of this under the SEBI Act, and even IRDAI, for example, has these, but RBI doesn't. So from RBI's perspective, the whole fact that they just came down and just stopped the business was suddenly everyone was taken by surprise. So I think from that perspective, if one looks at it, in 10 years back, in fact, the Financial Services Legislative Reforms Commission had actually spotted this regulatory gap. And they had in fact advocated for, instead of SAT having a financial sector appellate tribunal, so sort of give a statutory right of appeal. Because if you look at it today also, like for SAT, even the appeals, even any order, any person aggrieved from IRDAI or PFRDA or even SEBI, they all go to SAT. But as far as RBI is concerned, if there is any person aggrieved and he wants to take it up, he'll just have to file a writ. So I think from that perspective, spotting this regulatory gap, they had in fact suggested this reform. So I think from the whole point is today, when we look at all of these happenings, I think it is about time that these kind of reforms probably, if the RBI also could be brought at par, with other regulators. And I think there'll be two advantages. One is, of course, that then you have parity in terms of even looking at parties having a statutory right to appeal, right? The other also is that if one looks at the sort of the penal provisions that SEBI has at its disposal, some of it can also be looked at and sort of translated, over there in the RBI space. So, for example, you won't need to shut down business. You don't need to shut down business altogether, right? And there are others. So, from that perspective, I think these two things probably are the need of the hour.
If you have any counterpoints, you can make it, but it has to be less than 30 seconds. Okay. Mr. Dewan, to you. So since we're talking about FDI and cross-border transactions also, what are the critical legal and tax considerations for businesses that they have to really critically think about regarding the cross-border M&A transactions especially?
Yeah, hi. First of all, congratulations to all winners. So typically when you get into a cross-border M&A transaction, the first and foremost, companies are forming a joint venture or there is a private equity investment happening. The key challenge and foremost comes as the place where you're investing. So, if you're investing from a Mauritius or a Singapore or you're investing from US, that becomes a foremost, what will be the aspect. Of course, as just my colleagues were talking about press note 3. If you FDI is coming from a company which has a China angle, so that makes first and foremost, it's very imperative to understand from where the investment is coming in, because that will make a determination on stuff like dividend payment, royalties, or technical know-how fee. So once you're setting up a joint venture or setting up any investment, that becomes the first consideration. Then comes a consideration, it's very, very important to understand the tax aspect, because the taxation would be very, very different if, as I said, different countries or depending upon the double taxation avoidance agreement. That will make a key determination. And then also, the challenges come in terms of regulatory issues, the quantum of foreign investment permissible, because we still have, a lot of sectors where 100% FDI is not permissible. So if you are having specifically, foreign investment coming in defense or NBFC where it requires a RBI approval, or in some insurance. So therefore a JV or a joint venture coming in, so, we have to see a new necessity, like, what's the timeline? Because a lot of times we had joint ventures coming in sectors which require government approval. And if approval is not coming in, let's say next 6 months or 5 months, so there becomes a legal challenge. How do you operate the company? Because first and foremost, when you set up a JV or you set up a company, now two parties have agreed, there might be 50-50 partners in a company, but unless the FIPB or RBI approvals are not coming, the approval, the shareholding can't change in a company. So that becomes pretty much challenging how you fund the investment or the project, because recently we are working on a transaction where we had FDI investment into a NBFC, but delay in approval was costing the whole project because the timeline was the agreed timelines were not met as the approvals were not coming. So that becomes a very difficult task, because since the foreign investment is not coming because of some approvals, how do you make sure the business goes on or business carries on? Then comes as from a tax perspective, because we might be, maybe a taxation of a royalty or a technical know-how fee. The range of taxation is very, very different. And also does now, in fact, certain cases where a foreign company or a foreign partner says, I'm not keen to have a PAN number here, the incidence of taxation becomes much higher. And so it's very, as lawyers, it becomes very, very imperative what we add into the JV or, what we agree. Because in some cases, the foreign partners agree, look, we investing in your nation and we would like a grossing up because we won't get the benefit of this, the tax, whatever, we won't get any tax benefits. The grossing up becomes, especially in cases where there's a 20-25% of tax at source. So a 20% grossing up for the Indian JV makes the whole project at times unviable or becomes a huge financial burden, because both the parties are pretty. So these are issues we typically see a lot of times, like in cross-border mergers.
Mm-hmm. Yes, please, yes.
No, we see in cross-border mergers. Also, we've seen, like a big challenge these days because of the press note 3. Like, there is also a restriction on anyone who's a Chinese national. His being a director, he might be living in US, but he's a nationality of China or Hong Kong. He becoming a director in an Indian company, that requires approval of, so that requires HMA approval, and that becomes a pretty long drawn process.
Sorry, I have to just move in. We have 5 minutes and I want to do the impossible, which is get them to ask a question as well. When we talk about the regulatory framework and data, of course, is affected, and there is talk about data privacy and making it more localized. So, what are the challenges for businesses in this environment when these policies are taking shape?
Thank you for the question. And I guess the challenges, more than the challenges, I would say, what we've been talking about, and as a professor, when I teach a subject in my classroom, it's more of a bookish thing that this is the Bible and this goes everything. But I guess what has been seen in the real world is exactly what my fellow panelists, and I'm sorry that I'm the odd one out here who's not from that particular side, but to listen about, and I've been discussing with the, we generally call it with the PN3, the press, the note that we are talking here on to. But how wonderfully, and when the question comes that, okay, for me, teaching that is an NCLT thing. It's a very easy thing or a maximum NCLT thing. But how RBI, SEBI, and that was rightly pointed out as well. So this particular role, this particular mechanism is something that we have been learning. I guess something that we can even hint, and that's how the government, thankfully for that, is the ease of business thing that has been brought onto, which I personally feel is a best example of how a policy drift which Indian government has brought onto, not only with amending the laws, but yes, how the companies, which was rightly mentioned, Volvo is one of a leading example, which although we so rightly mentioned that it is majorly of how the Chinese have driven that particular thing. BYD is another example of how we are taking the automobile industry in that particular matter. So the challenges is that yes, we cannot pinpoint. There is no regular mechanism, and yes, the of different tensions that are being governing onto. So it's one thing that the countries govern. It's one thing that the countries are taking as a problem ahead. With one tension driving up, I guess that we might come with another press note that, okay, this is a country where things are not. So earlier it was Pakistan, then China, and then now how the things have been drifting onto. So the challenge that is there is more of how the things have been arising and the response towards the same. So just to see the time there, and it will be moving.
Scary,
forward.
yes,
Yeah.
yes. All right, Mr. Dubey, we talk about ease of doing business. At the same time, tax simplification is a challenge at the same time. And what steps are needed to be taken in this direction to make ease of business a reality and make tax more simplified?
Thank you. I'm a chartered accountant and sharing the stage with lawyers and esteemed lawyers. So I would say so. Thank you for that opportunity. I just when I heard about the topic, so I felt that I must come to this stage, and I put some of the points here. So I will start with Mr. Vaibhav's point that is connected to your. So there has a Ghar Wapsi has started definitely, and the one reason is that access to capital. The second most important reason I would say why the businesses were going outside India and they're still reluctant to come to India is the ease of doing business. And the most important part, what I feel towards that ease of doing business is the taxation, the tax reforms. Like Sir said, still the non-resident investors are not willing to take a permanent account number in India. Still, they are reluctant to get into tax net of India. So there is an image, we are a diversified company, we are not dependent on one or two industries like many other companies. Our systems has to be diverse. We are so that there has to be a diverse system for us. But yes, the simplification is in the process. Two major reforms I would say which were taken in the recent years. One was the introduction of GST, and the second was in income tax, the faceless assessments. So these two were the major reforms. I will start from here only. So there were certain challenges in GST regime itself. Few of my clients, and which I feel that must have happened with other companies also, they shifted their base from India to outside India after introduction of GST. These were typically SaaS-based companies, which were, their income was from outside India, 100% outside India, and their inputs were getting taxed. So there, in earlier service tax regime, there was no inward tax. There was no input tax if you are making an export. Okay, but here now the system is that even if you are making an export, you have to pay tax on your inputs and then go to government and claim a refund. Now let's just see what is the first impression of GST department. Just go and apply for a GST registration, and you will get the first impression of GST department. Okay, so my first submission is that make, to the maximum extent possible, make things faceless. GST registration should be faceless. Every registration should be faceless and a single point window. Okay, so that is my first submission. So every one of us, when we are into business, we like about single point of contact. When we are dealing with bankers, when we are dealing with any corporate or any complaint, what we like is single point of contact. Similarly, introduce a single window compliance. Okay, we file one return with MCA, one return with income tax, one return with GST, one return with PF. All the data are mostly same. All the year what businesses are doing compliances, auditing, assessments, investigation and all, right? In every department, MCA or income tax or GST or labor law, any department, there is one assessment, then there is an audit, there is an investigation. Why not make a single filing with MCA, make separate annexes to it that, okay, these are the assessment, my income tax return done. These are adjustment, my GST return is done. Okay, all the year we are doing TDS filing. Okay, TDS refund is claimed only once in a year. Why we are filing every quarter TDS returns? It is not required. No, there are many countries which are not doing this. There are only once in a year TDS filing, everything is done. So the second point is that make a single point compliance window. Do not ask businesses to go to every department. You make your centralized hub, get all the data there, share with all the departments. Okay, so that will actually impact your ease of doing business. Third point, all the departments are flooded with litigation. If you are able to, and most of the litigation reasons are mismatches in data. Your data in PF department is X, your data in GST department is Y, and your data is income tax department is Z. Okay, so most of the reasons of these litigations are mismatches. Okay, now you can go to any extent to create your appellate system, your departmental systems, and your high court. These, most of the cases can be resolved by structural changes at the root level. Okay, so those are my submissions. If we are able to do 2-3 things, ease of business can have a great impact on businesses. Thank you.
So I'll just take the liberty of just having 30-second comments. Anyone has anything to share? 30 seconds. Yeah.
It's fascinating to note that a tax expert did not bring up one very important change that happened this year, which was the removal of this nonsense thing called angel tax. As many of you might be aware, Indian tax law had this concept that if an Indian company had issued shares at a price higher than the fair market value, then the company had to pay tax for that extra delta, which is bizarre because you would expect investors to pay a premium if you want to build up in corporate India. So I think that's one very important change that happened, and I'm so glad it did. Lastly, I think for the benefit of the crowd, one very interesting trend that I've noticed is that as an M&A lawyer, we do end up spending a lot of time negotiating reps and warranties whenever there's an M&A transaction. That's premised on the construct that the promoter or the owner of the company owns a very large percentage stake. With more and more founders setting up companies, which by the time they've done a Series E, Series F, the promoters are down to 10-11%. And the rest of your cap table is all financial investors. And financial investors typically have this construct that how can I be giving reps on day-to-day business of the company? Because I'm a financial investor. Never mind, I may have all these rights under the contract, but I'm not the guy who's running the show on a day-to-day basis. And there's no point for an incoming buyer to take reps from a founder who only owns 9-10%. So off late, I mean, this is an interesting trend for me and myself that off late, if out of every 10 M&A deals, almost 7 to 8 of them are actually being done through rep and warranty insurances. I mean, this was a construct which we would debate about in conferences and the relevance of it. But now 70 to 80% of M&A deals are actually being done basis rep and warranty insurances. So that's an interesting trend.
Dewan, please keep it short, yes.
Yeah. So I just like to cap and say, it's been an amazing year where you see a lot of change in regulations, especially things like fast track mergers, which is make it possible for companies to, wholly owned subsidiaries and holding companies to merge, or a removal of cap between wherein you can have a share swap between an Indian company and foreign company. So definitely we're seeing the foreign investment is not only increasing, but the government is also realizing that they need to have more ease of business and the regulations are becoming more favorable for investors.
Okay. Okay.
So one more point.
Aditya's looking at me. All right.
Yeah, one more point I would just quickly summarize. So any policy related change has to be in a phased manner. It should not be in bing bang way. So like the service tax was introduced on few services, and then its scope was widened. Industry gets time to accommodate to this. Okay, so whenever a policy shift or policy change is there, industry must get time to adopt to it, so that gradual implementation should be the way forward in terms of ease of doing business.
Absolutely. And I have to interrupt, and I'm not liking it, but I have to end it here. Thank you so much for joining us. Can we have a round of applause for the speakers, please? Yes. Thank you.